All right, welcome to the Chapter 3 video lecture. Chapter 3 is the Criminal Act, which is the first principle of criminal liability. So the first principle of criminal law, coming back to last week, is the principle of legality. The first principle of criminal liability is criminal act. And we're going to call it actus reus throughout the rest of the semester. So the possible elements of criminal liability are actus reus, mens rea, which means intent, concurrence of those two elements, existing attendant circumstances, and bad result, i.e. you caused a harm. Now, you do not need every single one of these elements in a crime. State legislatures can kind of treat this like a menu where they select certain items. Now, if they do not have mens rea, they need to have a concurrent element. For example, drunk driving. Well, they can't. Driving isn't the problem in and of itself, assuming you're licensed and everything. But the attendant circumstance that makes it criminal is when you drive under the influence of drugs or alcohol. So there's not a mens rea. You don't have to intend to drive drunk, but if you do the behavior, drive, while under the influence of drugs or alcohol, which is in the attendant circumstance, then you have engaged in a criminal act. So there is a little bit of like a menu here for state legislatures and federal legislatures. In general, the menu kind of works like this. We have two different kind of menu items, if you will. We have criminal conduct crimes. For a criminal conduct crime, we're going to have an actus reus. We're going to have a mens rea. We're going to have one of these four levels. We're usually going to have a circumstance, and that is the criminal conduct. So if you engage in the action with the intent, usually with a circumstance, then you have engaged in a criminal conduct. The other type of crime are bad result crimes, and these are the more serious crimes, and these are almost always going to have all of the elements of a crime. We're going to have actus reus, mens rea, maybe a circumstance, causation, and a criminal result. This is a criminal harm. So we have to have a harm here for these types of crimes. So elements of a crime that we can pick from if we are legislating a new crime or adjusting an old crime are these. If we are just looking at criminal conduct, it's helpful to think of a specific crime here. So, for example, burglary. We have the act of breaking and entering the home or dwelling place of another. We usually are going to have an intent here. Sometimes it has to be a place that someone is currently living. Oops. Sometimes it has to happen at night. Sometimes it has to be like certain things are excluded. Then we have the conduct. You don't actually have to, and here you have the intent to commit a crime while you're inside the structure you broke and entered or you remained. But you don't actually have to complete that crime once you're there. You have completed the crime before that because it is a conduct crime, not a result crime. Okay, so if we think of our bad result crime, the easiest ones are like murder or rape. To think, we'll just go with murder here. You killed somebody some way, shape, or form. You poison them, you shoot them with a gun, you stab them with a knife, you run them over with your car, right? Any way that you do it, you engage in an action. You had the intent to engage in the action, or if it's a first degree, you purposely planned it out. We may or may not have a circumstance. So you actually have to be the cause if something comes up, like the person would have lived, but a doctor made a serious mistake and they died from that mistake, then you're not the cause of the death. So you have to be the cause of the death, and then the person has to die for it to be a homicide. It cannot be a murder if the victim does not actually die. We can charge you with attempted murder or a different crime, almost always, but it's not a murder without that bad result, okay? So those are the two types of crimes. You can see how they're different from each other. Now, this chapter focuses in mostly on actus reus because it's the first principle, and it is super, super duper important. We do not punish people for thinking just bad thoughts. We don't punish people for not being the best. We punish people for having those bad thoughts and then acting on them, okay? And this is kind of the idea of manifest criminality. You actually have to engage in an action or step or conduct that shows us your bad intent, show that causes the harm. And so that's one reason why actus reus is just so important. We need you to act for there to be a crime. Okay? Now, not only do we have to have an action, it needs to be a voluntary action. So your actus reus must be voluntary. There are a few different ways. There's a rationale. There's 4 steps to it. And the rationale behind this voluntary act requirement is that criminal law punishes people. Think back to chapter 1 in criminal punishment definition. We only punish people who are blameworthy. Okay, so we only blame people who are responsible for their actions, and people are only responsible for a voluntary action. So those are the 4 steps behind the logic of this principle. Now, actus reus is generally fairly clear-cut and easy to establish in most cases. And we're going to talk about some of the exceptions. So the first up is, according to the Model Penal Code, one voluntary action is enough. So conduct that includes a voluntary action is sufficient to satisfy actus reus. That doesn't mean that the last part has to be, or every single step has to be voluntary, but some voluntary action is required, and one voluntary act in the chain of actions or steps that got to the crime is sufficient. So your book has an example of this, State versus Burrell. We have some teens and one adult drinking alcohol. They get some guns. They decide to play Russian roulette with loaded guns. And then one of them decides they're going to steal the other person's guns. We have some threats going back and forth. Somebody comes running out of the basement. It literally says, "I'll blow your effing head off," and pumps the shotgun more than once. They looked at the other person to see what happened. The next thing they know, before they had time to do anything, there was a shot. The person was hit. They dropped to the ground. 911 is called. The defendant here tried to say that the last action that they engaged in wasn't voluntary, and therefore they should not be responsible. And we see the courts completely shut this argument down. Any voluntary act is sufficient. The defendant here, Burrell, engaged in more than one voluntary action, and that's enough to satisfy the requirements here for him to be convicted of conduct creating criminal liability. So it's a really interesting case. If you have questions about it, let me know. The next principle that comes up here is automatism. And automatism is the term for an unconscious bodily movement. So this includes things like twitching, sleepwalking, sleep driving. It includes behaviors like that. So those types of behaviors are not criminal because they're not voluntary. You don't have control over them. Now, one condition, epilepsy, that is usually has a special exception in statutes is about the driving requirements, and you have to be seizure free for so long, and if you don't, then you are responsible for the harm you may cause by having a seizure while driving. And your book has an entire section on epilepsy, and there's also a case excerpt here. So essentially it's their responsibility to monitor. If they miss their medication, they should not drive and things like that. There are other issues that occasionally come up here, like insulin shock or things like that. They're not as common, but it is possible that a judge could find that the person was engaging in automatism, and there is not any criminal liability. Now, fault-based defenses and affirmative defenses can come up here. The defendant can pursue a fault-based defense. This is where the defendant doesn't necessarily present an affirmative defense. And an affirmative defense are those excuses and justifications we talked about last week, and we're going to spend 2 chapters on: self-defense, insanity, duress, entrapment. Those things we have names for. A fault-based defense is where the defendant kind of sits back and creates doubt. They try to poke a small hole in the prosecutor's case so that not every element is proved beyond a reasonable doubt. So fault-based defenses are always evaluated when we consider actus reus, which is why it's on this slide. So we need to make sure that prosecutor has proved that there was a voluntary action, and if not, then the defendant now has a fault-based defense. Not every element was proven beyond a reasonable doubt, which we can contrast with an affirmative defense, where the defendant has to produce something and they have to show it by a preponderance of the evidence. So moving forward, the next part of actus reus that we need to talk about is that statuses are not criminal. So we cannot criminalize the character or condition of a person or thing. And for criminal law, this has come up with in the 60s, some states tried to make it a crime to be addicted to a substance like heroin. And the actual status of being a person with an addiction cannot be criminalized, because that's a condition of an individual. It is not a voluntary action. Now, the behavior itself, purchasing, using, distributing, things like those are voluntary actions that can be prosecuted under a separate statute, but we cannot criminalize a status like being an alcoholic or being addicted to a more hardcore substance. Those things cannot be criminalized. The behaviors that result from those statuses can be. So there's something important to note here. Robinson versus California was about being a heroin addict, and Powell versus Texas was dealing with whether it was a crime to be an alcoholic. Here we find they were trying to criminalize the pure status. Here, Powell was actually publicly intoxicated, which is, again, a specific action that was a result of his alcoholism, which that can be prosecuted. Okay, so the next thing we need to talk about is omissions. So criminal actus reus has to have a voluntary action unless you have a legal duty. There, if you do not fulfill your legal duty, it is a criminal omission, and that creates actus reus. Legal duties that you might have an obligation to do are the duty to report, the duty to intervene. You may have a statutory duty, a contractual duty, or a special relationship. Failure to report is like failing to file your income taxes, failing to register a firearm, failing to notify a sexual partner of your HIV status. Failure to intervene is not trying to interrupt a crime where someone might die or get hurt or property is going to seriously be damaged. Statutes can create a legal duty to report. For example, again, filing income taxes. You have a failure to report it, and it's also statutory. We also usually, certain people have statutory duties to report child abuse. contractual relationships are, for instance, if you hire a home healthcare aide and you have a contract with them that they're going to do these things, and they fail to get and administer your medications and you die, well, that's an omission of their contractual duty. They fail to appropriately follow your medication schedule. So the failure to give you your medication as prescribed, resulting in a harm, is an omission. And then lastly, there are special relationships. These are based on parent-child, doctor-patient, employee-employer, carrier-passenger, so like a bus company if you buy a bus ticket, an airline, and husband and wife in some states. So because, for instance, I have kids, I have 3 kids, I, as their parent, have a duty to make sure that they are fed, that they are sheltered, that they are cared for. And failure to care for my child appropriately could result in a criminal action, like child neglect or child abuse. Doctors have a duty to inform and report certain things, and the failure to do so, and that's based on the special relationship between a doctor and a patient. So these types of things can create criminal liability if you don't do what you're supposed to do. States generally operate under the American bystander rule, which holds almost every state has this. Like 48 states have the American bystander rule. So this is by far the most common. Indiana operates under this. There's no legal duty to rescue or help somebody. So if you don't have one of those obligations we talked about on the previous slide, one of those legal duties, you don't have to help a stranger. You don't have to get a baby off the train tracks, even if it wouldn't cause any harm to you. 2 states, I think, at least last time I checked, two states had the Good Samaritan doctrine, which does require everyday citizens to help those in need. So in a Good Samaritan state, if you walked past train tracks and saw an infant on the train tracks, you would have a duty to help that baby, to get the baby off the train tracks and to call for assistance. In American bystander state, you can walk right by that baby and have no legal duty at all if anything were to happen to the baby. So that's kind of the difference. Again, most states operate under the American bystander rule. Now, so we spent a whole bunch of time so far talking about the voluntary act and why. Then we start talking about these omissions. So let's talk a little bit about why. We require you to act if you have these legal duties kind of based on these 3. We restrict your legal duty to act based on 3 underlying assumptions. That individuals, your own conscience, peer pressure, will actually, most people will do the right thing. Most people would walk by the baby and help it even if they don't have a legal duty to do so. We don't want to continue to overburden the criminal justice system, which is already at capacity in a lot of ways. And criminal law cannot really force people to do the right thing or to help, and that's not really the purpose or role of criminal law, essentially. So that's kind of the rationale behind these. So again, actus reus is a voluntary action unless you have a legal duty to act, and then the failure to act is your actus reus. Now we're going to talk about one last type of criminal action, which is possession as a criminal act. This is a legal fiction. When you possess something, when I'm holding my pen here, this is not really an action. I'm not affirmatively doing something. I'm not trying to hurt or harm somebody. I'm not, it's kind of passive. I'm just passively holding this. Same thing with like my computer that's right in front of me. I'm not actually even touching it, but I'm still in possession of it. The thought here is that we create this legal fiction that you can be charged with possession for a good reason, to make society better, because harm comes from possession of certain types of issues like drugs and weapons and paraphernalia. These things should not be possessed by anybody because they are contraband, and to prevent future crimes and more serious crimes, we have created this legal fiction that possession is an action. There are a few different types of possession. Actual possession is me holding my pen right here. Constructive possession is like my computer that I'm recording on. I'm not actually touching it, but I'm still in control of it. It's in my home office. It is in my possession, even though I'm not actually possessing it. Knowing possession is required in 2 states. This requires that you cannot be convicted. Like, if you went to a garage sale and you bought a backpack and you're carrying it around the day you buy it, you get stopped by police, they ask to look in your bag, and you're like, yeah, sure. And then there was a bag of marijuana in there. In North Dakota or Washington, you cannot be convicted of that because you didn't actually know it was there. Most states, they'll operate under a mere possession rule. So in the other 48 states, exact same scenario. You buy a backpack at a garage sale. It has a bag of marijuana in it. You're walking around. Police come up to you and ask if they can look in your bag, and you say, yeah, sure. And they find that marijuana. You are in mere possession of it. It is in your backpack, which you are in control of, and therefore you're responsible for it, even if you didn't actually know it was there or actually put it there yourself. So those are the different types of possession to be aware of. All right, that ends our video lecture for chapter 3. There are a lot of cases that kind of illustrate some of these examples. So I definitely encourage you to work through them and to reach out with any questions. I will see you next week.